All right, folks, it's about that time. So today we will be talking about workplace harassment, and this is the next chapter that we need to cover as part of the human resource management segment of the textbook. So once again, we will be putting on our sport manager thinking caps and looking at legal issues within the workplace from a managerial context. And for us, it's important to establish value by using our knowledge of the law to identify potential legal issues before they occur and to use sound planning and policy implementation so that we can work to prevent, minimize, and address any potential legal liability that results from workplace harassment. And as you can see, workplace harassment can occur in a litany of contexts, whether it's harassment based on one's sex, race, religious beliefs, disability, their age, as well as in some states and municipalities, one's sexual orientation or gender identity. This chapter has to do with harassment, and there's different types of harassment like the last slide showed. We will be covering mostly sexual harassment and the different legal tests that have been developed through case law also have been applied to issues involving race-based harassment as well as sex-based harassment. It's also important to understand that the actions of employees in some of these situations can impact the liability for the employer as well. So it's important to have knowledge and awareness of the different trigger points that can lead to potential liability both for the employee and the employer. So the first type of harassment that the textbook references is sexual harassment. And sexual harassment usually is defined as any sort of unwelcome sexual advances or requests for sexual favors within the workplace. And there's a catch-all also for any sort of conduct that's verbal or physical that is of a sexual nature and also that is conditioned on being some sort of aspect of one's job. So how does that look in terms of different harassment claims? The two different claims within workplace harassment are quid pro quo harassment and hostile work environment harassment. So quid pro quo is a type of harassment where one's employment is conditioned on someone submitting to some sort of inappropriate sexual conduct. So they submit to that sexual conduct because it's made a term or condition of their employment. And that can be done through repetition and one of the built-in aspects of their job. So if you're a sideline reporter and you are routinely subjected to sexual advances or comments by your coworkers, whether it's at the gym or in the athletic facility or on the field, that could be potentially quid pro quo harassment. Also, submission to or rejection of the conduct is used as a basis for employment decisions. So that means that whether or not that person either agreed to that sexual conduct to be part of their job description or they rejected it is used as the basis to whether or not to promote someone, keep someone employed, or potentially fire them. And there must be a link made between that sexual behavior that is part of their job context and whether or not they were promoted, they lost their job, or they kept their job. And a tangible employment action is anything related to your job. But as you can see right here, that for quid pro quo harassment, that only applies to the actions of your supervisor because the supervisor is the only one who can actually punish someone for a failure to submit to that sexual conduct. So in theory, your coworker or a subordinate cannot cause someone to get fired because they don't have the authority. Now, I'm sure that's not the case in all situations because each context will drive this analysis. But traditionally, the acts of supervisors are what is the cause of quid pro quo harassment. And because it's the acts of supervisors, there is employer liability usually standard with this. So if a supervisor is found liable for engaging in quid pro quo harassment, again, this for that, if you sleep with me, I'll promote you, or if you don't sleep with me, I'll fire you, then the employer is also liable. So, for example, there was a scandal a few years ago involving former Arkansas football or head football coach Bobby Petrino, and it was exposed that he was having an affair with one of his younger subordinates within the football program, or it might have been within the athletic department. I believe that she was previously working in an unrelated area of athletics, and then she found her way into the football program working in player development. Now, if Petrino conditioned employment with the football team and this promotion with having an affair with him and having a relationship with him, then that had been quid pro quo harassment. And of course, then the University of Arkansas would be liable. Now, in addition to quid pro quo harassment, the second way to evaluate whether or not sexual harassment took place in the workplace is hostile work environment harassment. And hostile work environment harassment is briefly described as any sort of unwelcomed sexually related behavior. And it needs to be one sufficiently severe or pervasive as to create an abusive working environment, and that's something that would unreasonably interfere with the day-to-day of that employee. So here, hostile work environment harassment can apply both to the supervisor as well as the coworker, because virtually anyone can create a hostile work environment. And in addition, as the text states, employees are not the only party that can sue an organization for hostile work environment. An organization's customers or third parties that come and serve and provide services for the organization, like a UPS driver or someone who's an independent contractor, they could potentially file a hostile work environment claim. We're going to see that the potential for a hostile work environment claim as an example later in this lecture. So you're probably wondering what the terms sufficiently severe and pervasive mean. Well, don't worry. We will be talking about that in the next slide. But as a brief introduction here, if a plaintiff can show that the unwelcome sexual behavior was both sufficiently severe or pervasive, and it created an abusive working environment, then that would be the initial burden that the plaintiff needed to rise to, that the plaintiff needed to meet. And then the burden of proof would shift to the defendant. And the defendant here, being the employer, would need to show that the defendant exercised reasonable care to prevent or correct the harassing behavior, and also that the employee unreasonably failed to take advantage of those measures out there. Now, if that occurs, then the burden of proof would shift back to the plaintiff to actually show that that was just pretext. But what this affirmative defense basically means is that the defendant organization needs to show that the defendant company had some sort of policy in place to help any plaintiff or any employee that was being subject to discrimination, and that plaintiff failed to take advantage of that. And I'll give you some examples very shortly. So, like I said, hostile work environment claims have both objective and subjective environments. So, objective basically is the objective standard we kind of remember from the negligence unit, because remember that reasonably prudent person standard that we were talking about? Well, it kind of applies here as well, because the court will ask that based on the frequency of the conduct and the severity of the conduct, the question becomes whether or not from an objective standpoint, a reasonably prudent person in the same situation would have perceived the resulting climate as hostile, and then also whether or not the person, him or herself, also viewed subjectively that the situation was sufficiently severe and pervasive that it created a hostile work environment. And frequency means how often did it occur. Was this allegedly offensive conduct something that happened only once, or if it was happening every day? Now, if the employee was being subjected to requests for hugs only once, one request for a hug, that may in itself not result in a frequency that's objectively and subjectively hostile. But if it happens every day, if that person is being hugged every day, or if another employee is asking that employee out on a date every single day, then that frequency can rise to a level that is hostile. And then on the flip side, severity. Is it something, if it's an issue that only happened once and it wasn't that severe, it might not create a hostile work environment. But if it's something very severe, like a situation where a employee is subjected to some sort of sexually explicit image that another employee has pulls up on the computer screen and has that employee look at, or if something that's just very sexually inappropriate in the workplace, that could rise to the severity that's necessary to create a hostile work environment, even if it happened just once. So frequency and severity help to determine whether or not it is a hostile work environment. And then at the end of the day, the question is whether the conduct is physically humiliating, threatening, or merely an offensive utterance. So again, it's the severity of the conduct, and we're looking holistically whether or not all of this worked to unreasonably interfere with the employee's job performance. So again, there is an objective and subjective part of this test. So on the whole, objectively speaking, we're looking at how often the offensive conduct happened, how severe it is, whether or not there was some sort of physical or humiliating aspect, or if it's something that was just said as a passing quip, and whether or not it interfered unreasonably with the employee's ability to perform. So all of this is considered in a holistic analysis from an objective and subjective standpoint. So if the employee does not subjectively believe that he or she was subjected to some sort of hostile work environment, then the lawsuit would fail, the claim would fail. And so coming back, let's say that we're going to talk about, again, the burden of proof. So once the employee provides the initial burden that there was a hostile work environment subjectively and objectively, then the employer needs to show that the employee actually had some sort of program in place to demonstrate that they exercise reasonable care to guard against sexual harassment and to correct that sexual harassment, and that the employee did not act reasonably, him or herself, to actually take advantage of these mechanisms. So some examples of employers meeting their burden is if they took time to create an anti-harassment policy handbook, or if the employer had in place anonymous reporting policies that would that would allow the employee to submit something online without any sort of identifying information that would go to a third party to report that claim, and there'd be an investigation. And the employer needs to also enforce these policies. But the employee can rebut this defense by saying that this was just pretext or that the complaining method was not effective. So, for example, if the employer actually had in place some sort of program that allowed for anonymous reporting, but that's one thing. But what if that anonymous reporting would actually that the message would go to the other employee who was doing the harassing, so it wouldn't do anything to solve the employee's problem. So if that's the case, then it would be a way to show that the employer's policies were ineffective. So that would be bad. So when we're talking about quid pro quo harassment, it's fairly explicit that it's going to be the employee must submit to the employee as part of the working conditions of that job need to submit to those sexual demands. But in terms of hostile work environment, there's a usual set of conduct here that contributes to a hostile work environment. So it would be touching, patting, catcalling, whistling, comments, notes, letters, emails, looking, leering, obscene jokes, and anything related to that. So all of these different types of conduct can contribute to creating a hostile work environment claim for the plaintiff. So when we're actually looking at a hostile work environment claim, you need to look at whether or not the offensive, if it was speech, if that speech was offensive or that was sexual in nature, or whether or not the offensive speech or harassment was based on the victim's gender and it was thus based on sex. So here, if we're not just talking about sexual harassment, there could be gender-based harassment or race-based harassment, and you would still use the hostile work environment test as a way to demonstrate that that this plaintiff was subjected to an environment that was unreasonable and that it interfered with their ability to carry their job because it created an abusive working environment. So I want to give an example of a potential sexual or hostile work environment claim that occurred a few years ago involving Anise Sands, who is a television reporter for, I believe it's TV Azteca, and there was a situation that erupted with the New York Jets where she had gone to report on Mark Sanchez, who was the quarterback at the time, and Miss Sands had, let's just say, she had garnered the attention of the players, and several coaches actually made sexually explicit comments, and also one coach was throwing a football very close to the reporter so that players could come and flirt with her, and then additional Sands faced additional issues when she entered the locker room to interview Sanchez. So I'm going to play this, and you guys tell me whether or not you think that this is sexual harassment.
Did you ever notice that there were footballs being thrown in the direction where you were during the practice?
Well, actually, yes, I do. I was there, and suddenly they start to practice and throw the ball exactly in my side. But I never take it seriously. I think he was only joking, and I really don't even pay attention by that because they never hit me with a ball or something. I wasn't in danger in this exactly moment, so I let it happen and then wait for the locker room to catch Mark Sanchez there and make the interview with him.
Did you, okay, let's take the next part then. There have been a lot of questions about that incident, which you just confirmed happened. There have been reports in the New York Daily News and in the New York Post as well that it wasn't just the players, but that some of the coaches were also involved in that. But let's take it to the next step. Now you go into the locker room where the players were, one of many members of the media who are working that story with the New York Jets. You wanted to do an interview with Mark Sanchez, and it's reported that there were catcalls and hoots. Did you hear that? Did you hear that reaction? And how did you deal with it there?
Well, actually, when I get into the locker rooms, I obviously in the moment that I get in, I feel all the eyes on me. So I decide to find where is the Mark Sanchez locker and walk in front of them. So to be honest with you, I try to not hear anything, try to not pay attention. My cameraman told me, don't look at the right, don't look at the left. So I only saw the Mark Sanchez locker, but I really feel the noise and all the environment was talking about me. So one colleague, one female colleague, come with me and tell me, I'm so sorry, it mustn't happen, it's not okay. So I try to calm her and say, don't worry, I'm only focused on my work and I only wait here for Mark and I don't even pay attention in what happened. So I treat her that I feel a little uncomfortable in the environment, but I was waiting for Mark Sanchez and I prefer to stay only in front of the locker and not to see any other part.
That's interesting, Inez, because what you have just said is that another female reporter there, a colleague of yours, felt embarrassed for what was going on, embarrassed for you. So then let me ask you the question. Yeah. Did you ever feel embarrassed?
Well, actually, yes. I feel a little uncomfortable because evidently it's not easy to be in a locker room and hear and notice that everybody is speaking about you and probably making some jokes. But I never feel in danger also. I'm a professional. I have 8 years making interview with the best players. So I know that in some moments you must be calm, relax, and only wait for your work. So what I try to do is not to pay attention and not let that this thing disturb me. But I really know that she hears some things that I didn't hear, and the rest of the media that is inside hear things that I really didn't hear. So
that's interesting.
I really appreciate the concern about it.
Let me ask you another question, and this has to do with what's gone on since. You know, this has become a bit of a controversy. People, women's groups around the country have filed complaints. The NFL now says it's investigating, and there's a report out that you have received a call from one of the Jets officials. In fact, there's a report out there that you actually got a call from the owner. Is that true? And if so, what did he tell you?
Yes, absolutely. In the morning, Sunday morning, I received a call. It was on part of the Jets.
Okay, so the Jets owner apologized. So okay, so let's go back to our analysis here. In order to have a hostile work environment claim, there needs to be several elements present here. It needs the conduct that's complained of needs to be sufficiently severe or pervasive to create an abusive work environment. And so the plaintiff needs to meet both prongs here. The subjective and objective elements that, based on the frequency of the conduct and its severity, whether or not it was physically threatening or humiliating, and whether it was conduct that unreasonably interfered with the employee's work performance, or if it was just an offensive utterance that did not prevent the employee from actually doing their job. So, sure, we've got some catcalling, we've got some whistling, we've got some horseplay. First of all, it doesn't matter that the reporter is not a Jets employee. It's a third party. It's like the UPS person coming by. I'll let you guys figure that out on your own, but the answer is in the reading. Secondly, are both prongs of the hostile work environment test met? Did she objectively and subjectively meet these prongs? So objectively, it's based on a reasonably prudent person. So that standard would need to be met regardless. But she says herself that she did not feel like she was sexually harassed. She said she was a bit embarrassed, and she also mentioned that someone else came up and felt worse than she did. So with that being the case, her claim would not be able to go through because she subjectively does not believe that she was a victim of sexual harassment. Now, this also mirrors a couple of the cases in your textbook where you had situations where a subordinate was in a work environment where he felt like he was being harassed, that there was different conduct that it was occurring of a sexual nature that offended him. His buttocks was grabbed. He faced some physical conduct from his female supervisor, but objectively speaking, the court said that it did not rise to a hostile work environment. So in any case, this is an example of a potential sexual harassment claim. Now, if we're still wearing our sport manager hats, we need to think about, well, how do we prevent situations from degenerating where the organization and potentially the individual might be liable for sexual harassment or race-based harassment pursuant to a hostile work environment claim? And it starts with developing a comprehensive policy that is separate from an anti-discrimination policy, and make sure that employees are aware of it and that the policy is explained and enforced. And make sure that the policy also covers not just sex-based discrimination, but also racial discrimination, religious harassment, etc. And this policy should be updated frequently. There should be workshops, and there should be effective provisions within the organization where if an employee is facing what he or she describes or perceives to be as discrimination, whatever the context, then there should be some sort of procedure that would allow the employee to effectively report that and start having these concerns investigated and eventually remedied. It needs to be prompt, and certain protections need to be given to the complainer, and the organization needs to make sure that this is in place. So within the context of sport, oftentimes we have discrimination and sexual harassment in school. It could be that the school is singling out someone and creating a potential hostile work environment based on the conditions that they face on a day-to-day basis. But we've also seen more recently sexual harassment of coaches harassing athletes or administrators harassing coaches. We read that one case where there was a white coach in a historically black college who felt like he was being discriminated against because and harassed because of his race, and that he faced quite often comments from other people within the organization that referred to his race and that were making it difficult for him to perform his job. Ultimately, he was unsuccessful in his lawsuit, but that's certainly an example. We also see an increase in female coaches working in sports a dramatic decrease in female coaches working in sports. That's one of the regrettable byproducts of Title IX. And we're seeing peer-based discrimination in athletics, whether it's hazing or whether it's players who are complaining about lewdness in the locker room. There was one example where a female place kicker walked on at the University of Colorado, and she, based on her treatment by the rest of the team who were male, said that she felt like she was being treated as a piece of meat and called names that were completely despicable, and that the coach did nothing to address that, and she ended up suing and getting a settlement. So when you're actually, as an administrator, trying to create an anti-harassment policy, it should be founded on the philosophy of zero tolerance. So one incident of harassment and is too much. So also that policy should describe what it really means from a legal definition to engage in sexual, racial, or religious harassment, and citing proper examples. Reporting procedures should be clearly outlined, and the investigation process should be clearly described. And finally, there needs to be different descriptions for penalties, and then a clearly articulated appeals process. These different elements for a harassment policy will help with one, preventing harassment within your organization, and then two, if harassment does occur, effectively dealing with the logical consequences of that harassment in a way that does not result in litigation or liability, and in the unfortunate circumstance where there is litigation, that the employer can show that its burden was met in that it had a proper anti-harassment policy on the books, and in that employees knew about it, and it was well known, and it was constantly updated and effective. The final elements of the chapter deal with a litany of different aspects involving issues of employee expression. So we've got employees who are seeking justice for or seeking to engage in whistleblowing. So you can refer to that if you want in the textbook. We see issues involving employee dress or grooming, or religious speech or religious practices. So one to highlight is religious practices, where you had in the textbook a plaintiff who observed the Sabbath, Friday night sundown to Saturday night sundown, in that he alleged that he was fired because of his religion, but of course the court, based on the facts of the case, found that actually that was not the reason why the plaintiff was fired, but instead the plaintiff was insubordinate. But a popular example of harassment or discrimination based off of a religious practice is grooming codes, where organizations require employees to be clean-shaven or not have facial hair down to a certain length, and some religions actually do not allow people who observe to shave, and if that is the case, then that could be a potential violation of Title VII based on religion, treating similarly situated people differently. Or religious speech. The United States Constitution has the freedom of speech elements in it, where we've got the Establishment Clause, as well as that anyone can practice a sincerely held belief as a religion, and that the United States cannot appear to endorse a specific religion, which is where we had the case of the football coach who, for over 20 years, led his teams in prayer before games, and then when he was forbidden from doing that. When the team led the prayers, he knelt his head and kneeled down with them, and that was perceived to be a violation of the endorsement clause as opposed to the free exercise clause. So again, these are things that are worth checking out. Now, I close by talking about a couple of examples that have come up over the last few years involving employees within sport where issues of harassment or free expression became an issue of legal prominence. So, of course, hopefully some of you remember the Jonathan Martin, Richie Incognito harassment saga that occurred, I think, in 2014. And it involved hazing Jonathan Martin, who was a rookie for the Dolphins at the time, and Richie Incognito as a veteran, subject him to continue with name-calling and other sorts of harassment. And he ultimately quit the team and ended up filing a harassment lawsuit against the Dolphins. So it calls into question what really is acceptable within the professional sports workplace. When one enters a locker room, often that person who is a professional athlete does so at their peril, where sophomoric sort of aspects of society still are in play. So, there's been a movement towards bullying and getting bullying out of school and getting it out of the workplace. But how does that mesh with situations where sports like football and contact sports, where violence and hierarchy and male sort of being an alpha male are traits that are not only cultivated but prized within professional sport? So it's sort of a juxtaposition involving sort of the anti-discrimination and harassment laws that exist in most workplaces, but how can they be applied when football and other contact sports aren't really abiding by similar rules as in the professional workplace? And then the next wave of sort of issues that are coming to the forefront are issues of employee expression from a professional sports standpoint. So at the time of this recording, a national firestorm has really erupted around Colin Kaepernick, who is a quarterback who currently plays for the San Francisco 49ers. And about a week or so ago, maybe longer, he decided to protest the way that people of color are being treated in the United States by not standing for the United States national anthem. And he wanted to use this as a discussion point. He has received support from both the 49ers and the NFL in the sense that they are not going to penalize him for his conduct. And that's significant because although Kaepernick does have freedom of speech and the freedom from being punished for his speech, that freedom from punishment really only applies to the federal government and governmental entities. And the NFL is a private entity. Really, they have a right to police their employees and hold them to a certain level of conduct, so long as that's balanced with acting reasonable under the circumstances. So, and this is at the time of this recording. Now, other professional athletes are rallying to Kaepernick's defense and are also engaging in their own demonstrations. Whether it's Megan Rapinoe, who also took a knee before her soccer match, and then the Seattle Seahawks are rumored to be planning their own protest as a team before their season opener. And then on the right, the textbook references another gentleman who engaged in his own reflection and decision not to stand for the U.S. national anthem. His name was Sharif Abdul Rauf. I'm sorry, actually Muhammad Abdul Rauf, and he had converted to Islam, and he had objected to standing for the U.S. national anthem as a violation of one of his tenets of Islam. And of course, at the time, the NBA punished him, and then he objected because it was his sincerely held religious belief. And if he had sued, then the NBA may had violated his religious beliefs. So ultimately, the two sides struck a deal, and here is the product of that deal, where Rauf would stand for the U.S. national anthem, but he would be praying on his own and averting his eyes to the American flag. So those are a couple of instances where issues of employee freedom of expression have come into play within the professional sports realm. But for the takeaways here, as future sport managers, it again goes back to knowledge and awareness of the law and how to craft different policies to limit, sidestep, or otherwise avoid potential liability. So this concludes this lecture, and I look forward to catching up with you guys on the next one that we do.